Thank you very much for that kind introduction, Tran, and I'd like to add my congratulations to all of the authors of articles in this volume and to you and the other editors who've done such hard work in bringing it to a successful and, we can hear, substantial conclusion. The occurrence of communication surveillance and big data in a title brings privacy issues immediately to mind, but the articles in this issue have a much broader scope than the privacy thread. Issues of discrimination, of automated decision making, of democracy and of the public's right to access information are all also thread through these pages. In one form or another, big data is the common element. And it and data privacy are the aspects on which I'll concentrate in my remarks this evening. But big data is a puzzling concept, sometimes described as any collection of data sets so large and complex as to be beyond processing by normal tools. It's therefore not surprising that big data analytics takes on something of an aura of mystery, tools to process that which cannot be processed, and the conclusions and decisions that result from this processing also have some degree of unapproachability. In the reality of a particular company or agency's operations, big data, I think, is more accurately often described as bigger data than was previously attempted to be processed, drawn from more disparate sources, including often transactional data and social media data, and with different data structures or lack of structures than was previously common in processing. There are two articles in this volume that provide, I think, a good start to understanding big data. Burton and Harper give an illuminating analysis of the practices of data analytics in the employment context, which they call talent analytics. The big data they write about is big in the unprecedented intensity of its scrutiny of the actions of employees or potential employees, rather than big in the sense of involving vast numbers of people or, in some senses, vast quantities of data. But like other big data practices, and typical of them, the practitioners in this area advocate the collection and analysis of all data that can be obtained, no matter how seemingly irrelevant, in the hope, and sometimes the hype, that statistically based analyses can produce non-intuitive correlations between aspects of applicant or employee behaviour, such, for example, as what browser they select to browse the internet, and desirable traits in the workplace, such as punctuality, for example. Now, this ideology of substituting correlations for attempts to understand causation is one of the things that's at the heart of big data and its analytics. One of the earliest proponents of big data, Chris Anderson, the general editor of Wired magazine, proclaimed correlation supersedes causation. So Burton and Harper compare these big data practices in the employment arena against anti-discrimination laws in countries such as Australia, where there are certain protected attributes, race, sex, ableness, age, genetic predispositions, which cannot generally be the basis of decisions in particular relationships, including the employment relationship. They argue that it's almost impossible for these laws to be applied when decisions are made on the basis of talent analytics, because it's usually almost impossible for either data users, the employers, or data subjects to know even when the data is being used to make decisions, or what data is being used to make decisions. Now, this is very important if we're to preserve the hard-won social policies represented by anti-discrimination laws, and to prevent the hidden heuristics of emerging employment practices starting to mean that data is destiny. And I think it's this possible lack of transparency that's one of the overwhelming problems of going from data to decisions, as a new research centre is called. In some contexts, like, say, recommending to Amazon users which books they might like to buy, it doesn't much matter how you got to the destination. And that may apply too to some of the things that our host referred to, such as urban planning decisions based on traffic patterns. It might much matter in that context. But in other contexts, like employment decisions, you both have to know what route you've taken to get to a decision or destination and be able to justify the route that was taken. Correlations can generate unexpected hypotheses, but some decisions can't be made on the basis of hypotheses alone. There are the literature about big data reveals other problems that recur. Data scrubbing is an essential first step in all big data processes, particularly where data sets from disparate sources are combined. This means that some categories of data are discarded and other categories are modified to make them more computable. Every such decision to discard or amend is based on some theory of what is relevant and what is not. There's no such thing as allowing big data to speak for itself. And another aspect, one that Burden and Harper didn't pursue, is whether the intensive personal data collection they describe as the starting point of talent analytics, which they describe as the collection of a log of the employee's activity throughout the working day, should be acceptable. To what extent should constant workplace surveillance be acceptable in an industrial relations system? And even if it is only, as they say, the metadata comprised in the continuous details of an employee's use of company systems, whether computer systems or toilets. To what extent should that be collected and correlations drawn from it? And it also collides with the data minimisation principle in privacy laws. Now, the other article I think that's very valuable in this context is that by Bennett, Moses and Chan, which focuses on the logic of the processing of big data, the data analytics side, in the application to decision making in the legal system and law enforcement. They argue that although the techniques often used there are still rule-based, though utilising machine learning, and again that the rules are often opaque to end users. In arguing this, they point out that many of the issues that proponents of big data techniques will have to face have been well trodden 30 years ago or more in the 1980s era of expert systems. And the legal profession has been very discriminating in the tools it's adopted that purport to simulate the application of expertise. And similarly, in police information systems, including sentencing databases, the result has been to only accept those tools that augment human decision-making rather than replacing it. So in domains like this, a sort of black box approach to correlations is usually not acceptable. Conclusions or decisions must be both transparent in their reasoning and justifiable. And these problems recall to me a previous iteration of computing practices that were going to make everything different. Japan's fifth generation project of the early 1980s generated similar enthusiasm, and many believed it would make Japan dominant in computing within a decade, based on parallel processing and an earlier iteration of massive databases. Now, obviously that didn't happen, and it was an expensive and embarrassing failure. History doesn't usually repeat itself, but it does give repeated warnings about hubris. And big data analytics, although they're certainly not likely to go away, but in coming years we may see that their ambitions and scope of operations become somewhat more modest. Going through these essays in the special issue, a common element seemed to me to be pessimism. Little enthusiasm from the authors for the promises of big data, many concerns about its dangers, and a somewhat shared dismay by the authors at the inadequacy of privacy laws to deal with the problems raised by both big data and surveillance practices. I mean, it's not surprising, is it? It's a common perception in 2014, particularly a year after the Snowden revelations started, that individual privacy is more under threat than ever before. Media reports and most people they interview can reel off lists of concerns: search engine tracking, social media, cloud computing, state surveillance, data spills, big data, and so on. Now, it makes me stop and ask, are all of these things and the feelings that people seem to have now simply developments on a continuum of gradually intensifying and expanding surveillance? Has this just been occurring incrementally, like the boiling frog, since at least the late 1960s, when concerns were first raised about databanks of personal information? Or has there been some fundamental discontinuity in surveillance and social practices in recent years? If there has, well, what has fundamentally changed? And what's the root cause of any such discontinuity? Now, in the preface I've written, I've listed a brief and incomplete catalogue of what I've called categories of factors that certainly have made the protection of privacy much more difficult. There are environmental factors. Moore's law has been mentioned, the progressive elimination of processing costs. Similarly, the gradual elimination of data storage costs and the explosion of online transactions. All these contextual factors make the other problems more intense. The collection and secondly, the collection and generation of usable personal data has proliferated both in forms and quantity. The digitisation of far more types of data than before. Visual data collection, voluntary disclosure of information through social media, personalised interactions without identification through mobile devices, geolocation techniques, the removal of anonymous options in transactions that's constantly occurring, the explosion of re-identification techniques that are now far more powerful. All these things just mean there is far more personal data. Thirdly, that data is processed and used in far more intense ways. Data analytics that we've been talking about, the functions of search engines and ranking systems, for example, and the increased interconnection in both the private sector and state sectors of data. Fourth, there's also increasing retention and reduced security of personal data. Just think how much more of our own data we keep on our own devices, all sorts of devices, and keep it permanently in a way that didn't happen before. And how many other organisations, third-party bodies, permanently store much more massive amounts of data than ever before. And then you couple that with the endemic failure of security systems. The fact that most personal data is stored in legacy systems using legacy software from 20 or 30 years ago with new fancy top ends on the front of them, but causing discontinuities in security and resultant massive security problems. And finally, of course, increased disclosure and transfer of personal data through surveillance by both the local state and foreign states, as we now know, international data mobility through cloud services and the like, and malicious hacking, markets in stolen personal data, the use of botnets and the like, to an extent we don't even know, and unintended data breaches of massive scale everywhere. Every step in the life cycle of personal information has become more dangerous to us. And every one of these steps has a multiplier effect on the dangers in the other steps in the life cycle. It's no wonder that people are worried. But back to my original question, are we just boiling frogs? Or has something fundamental changed? I think if we look back to the Internet 1.0, around 2001 when the first internet bubble burst, and look at the internet boom from 1994 to 2000, before that, the first internet age. That was largely based, I think, on the belief that particular classes of users of the internet would be attracted to particular websites by such quaint things as memorable domain names, at which point marketing to them could take place. But all that's changed. Since then, internet commerce has been to some extent redesigned around the maxim, when the service is free, the user is the product. And the aggregation of information about individuals for the purpose of on-selling that information for further marketing purposes has come to predominate the way the internet operates. Internet 2.0 does, to me, seem to involve some qualitative change. The user is the product. And simultaneously, we've had the explosion of both voluntary disclosure of personal data, user-generated content, social media, etc., and of mobile devices and geolocation. These things have made constant participation in the internet and related technologies possible despite physical location. Julie Cohen identifies this as the participatory turn, and which increasingly involves what she calls gamification of user interactions. Stage competition with known and unknown peers to increase people's motivation to disclose personal data. That we're increasingly encouraged to compare ourselves to people we do know or don't know and disclose more personal information as a result. And she argues that this is part of a developing ideology that positions surveillance as a partner of innovation and fun as well. No longer a potential danger to be regulated, surveillance is positioned as a source of innovation to be encouraged, a prospecting tool of the new biosphere of personal data. And this fits in very nicely with the correlation ideology of big data. So, this is on this hypothesis, and it's no more than that, I think there may well be a seismic shift in relation to privacy. And big data analytics is part of it and one of its key features, but I doubt if it's the defining feature. Well, that's all sort of mainly private sector stuff, but coincidental in timing with the end of the bursting of the first internet bubble, was the 2001 attacks on New York City and the shift to vastly intensified state surveillance that followed. So our privacy has been under a two-fronted assault from both public and private sectors for over a decade now. And that assault, government surveillance, is addressed in this volume of the New South Wales Law Journal in 3 papers. As we know, since July this year, there's been extensive debate in Australia of the Abbott government's active pursuit of data retention legislation. Metadata. The term metadata has decisively entered the Australian lexicon, but no one in government will yet define what they mean by it. Lackmeyer and Witzleb in this issue compare these debates in Europe, the USA and Australia. And one thing I would note is that the European Court of Justice's decision that the EU's data retention directive is invalid demonstrates that state intrusions into privacy are not irreversible. And at least that's a hopeful sign. But those authors point out the rather dismal lack of constitutional and statutory protections in Australia and the fact that they're unlikely to be developed as part of the data retention debates here. And similarly, Deswart, Humphreys and Van Dissel are pessimistic that current concepts of privacy based on controlling collection, storage and use of categories of data are capable of controlling privacy intrusive practices in either sector. And of this trio of articles, finally Chelsea Manning, Julian Assange and Edward Snowden make an appearance and raise another category of big data issues where very big sets of government-held data and details of government surveillance practices are made available to the public. Hardy and Williams analyse the legal consequences in Australia of this enabling of surveillance of government actions, but find very few protections in Australian law, at least where information concerning national security is concerned. Big data, it seems, is only allowed to flow in one direction. As I say, it's a series of rather pessimistic articles that we find in this journal. I want to conclude by just saying a few things about the significance of pessimism about privacy and data privacy laws in particular. As I question in the title of my foreword, does it mean we should abandon hope that law can provide any protection against big data and a society increasingly based on surveillance? Well, across the globe, both the content of data privacy laws and the means of enforcing them have been emerging for 40 years in a somewhat iterative development of stronger international standards and stronger national laws. Since the first national data protection law in Sweden in 1973, 105 countries have now enacted laws protecting data privacy or attempting to. These laws were concentrated in Europe at first, but with the recent passage of new laws in Brazil and a number of African countries, as of 2014, the majority of the 105 laws are for the first time from outside Europe. In each decade since the 1970s, the total number of countries with new laws has approximately doubled. 10, 21, 41, 80, and in the first 4.5 years of this decade, another 25 new countries have enacted such laws, and a further 17 have official bills awaiting enactment. If this acceleration continues, between 130 to 160 of the approximately 220 states and independent territories in the world, or self-governing territories in the world, will have data privacy laws, including most economically significant countries already. So we're proceeding toward global ubiquity of data privacy laws. And it's not only the number of laws, but their content that's significant. I conducted a study in 2011 of 31 of the 35 laws outside Europe at that time, and showed that on average they included 7 out of the 10 most important factors that differentiated the 1995 EU Data Protection Directive from the much weaker 1980 OECD privacy guidelines. So, countries worldwide were not adopting just the basic OECD standard of the 1980s, they were implementing most of the higher European standard of the 1990s. And that's continued in the adoption of new laws since then and the revision of existing laws. The only country going in the opposite direction is Japan, which is considering changing its law to facilitate big data practices. So this is an example of what in other contexts has been characterised by Zaki Lady as the global soft power of a European standards-based approach. Now, that's sort of the positive side of what's been happening globally with data protection laws, but everywhere, including in Australia, effective enforcement of such laws has lagged behind their enactment, encouraging the justifiable pessimism that we see exhibited in some of the articles in this issue. But this too, I think, is changing somewhat. Fines of over €100,000 for privacy breaches have in the last few years become common in Europe. And in 2013, privacy breach fines in Spain totalled €19.5 million. In Australia this year, it became possible for privacy breaches to result in fines of up to $1.6 million under federal law. No, it hasn't yet happened. Recent changes to Korean privacy law are very likely to result in hundreds of millions of dollars compensation for data spills. And Singapore's law allows $1 million fines. So everywhere, enforcement is ratcheting up in theory and in practice, but still far from sufficient to deter the largest global privacy invaders. However, the EU's proposed data protection regulation, which is likely to be enacted next year, will include fines that can be at least 2% of a company's global turnover, according to the European Commission, and up to 5% if you listen to the European Parliament, possibly with a cap of €100 million for a single event. And that will apply to foreign companies operating in the EU, as Google and others have discovered does already with the right to be forgotten. So maybe the billion-dollar privacy sanctions are not too far around the corner. So both national and international strands in the development of privacy protection are continuing to strengthen. But nevertheless, the reality is that strengthening privacy laws are everywhere overshadowed by the ability, whether legal or not, of US-based companies to hoover up the personal data of people in the rest of the world and to process it and use it with very few restrictions, because there are very few restrictions in US law. At present, privacy standards in other countries don't matter so much if personal data can be liberated to the US safe harbour. So that's the reality of collision between practices and laws around the world. But just on a final note, we shouldn't forget that a very similar situation prevailed a century ago when the USA was the pirates' harbour of the copyright world, to the despair of authors and countries with then emerging international standard copyright laws. National attitudes to laws can change 180 degrees with changes in business models, as occurred with the USA and copyright. The US finally joined the Berne Convention after 102 years in 1988, and of course is now the world champion of stronger copyright protections. So the prevailing US model of an internet where the user is the product is not necessarily permanent. However, to stop it becoming so, it'll take either a second internet bubble to burst or a concerted effort by the rest of the world to reject privacy-invasive business practices, or both. Neither's impossible, but neither is likely to occur rapidly. There are plenty of reasons to be pessimistic about privacy protection, but that still doesn't equate to fatalism in the modern guise of technological determinism. The future of privacy is still a matter of human agency, both collectively and, for that matter, for each of us as individuals who can decide to be more vigilant in protecting our own privacy. So I hope you enjoy reading the articles in the special issue. Thank you.